those who are familiar with patent jurisprudence will certainly vouch for the fact that patent language and claim language differs from jurisdiction to jurisdiction. Standards of patentability and validity of patents differ from jurisdiction to jurisdiction, because that falls within the scope of sovereign rights of the country to decide what is patentable within the meaning of its own act. Therefore, assuming that your US patent is valid, that doesn't necessarily mean your Indian patent is valid. You'll have to test it separately. So until that issue is addressed, no amount of investment that you may have poured into that particular invention can support you or help you in the grant of an interim injunction. Let's get that very, very clear. Now let's assume for a moment that validity is established in your favor. Infringement is established in your favor, and all of this only at a prima facie basis. What remains is irreparable harm and balance of convenience. Why do you need to look into the aspect of irreparable harm if the questions of validity and essentiality are already ruled in favor of the patentee? Because the answer is straight and simple. The grant of an interim injunction cannot have the effect of wiping out the defendant during the pendency of the trial altogether, because that's why you have the aspect of balance of convenience. The court's primary duty is to strike a balance between the private interest of the patentee and the private interest of the defendant. And in an issue such as the standard essential patent, it has to strike a balance between the private interest of the patentee and the public interest of the rest of the people, because it has very different ramifications, as they rightly say. On the question of irreparable harm, what is Indian law? Something which is compensable by way of damages at trial is not irreparable harm. That is the test. Does this take into account the longevity of a trial? Does longevity of a trial or the delay in Indian trials necessarily affect this particular assessment? I don't think so. Assuming if it does, then it should actually go against the patentee. Why? Assuming that you enjoy an injunction, an interim injunction, and the trial is delayed for one reason or the other, and you have absolutely no incentive in prosecuting and pursuing the trial actively, what happens to the defendant? Why is this important? Because at the end of the day, a standard essential patent, particularly in the telecom sector, affects and plagues every product line, every product segment, which means if an interim injunction is granted, it's not just one product line that sees closure sesame. The entire company has to close its doors. It has to shut its doors. This issue has to be understood. So going purely on the basis of Indian law without even getting into FRAND jurisprudence, I think when you answer the question or when you address the question of interim injunctions in the context of standard essential patents, the law is against you. Now let's bring in FRAND. When you bring in FRAND, of course, you may have compromised by saying that I will not have access to injunctive remedies because I'm lending this particular patent as part of the standard, but that's something that you've volunteered to do so. You've not been forced to do so. Let's assume for a moment, even if you're forced to do so, that's because there are certain benefits that you enjoy when the patent is adopted as part of the standard. Now, when it becomes a part of the standard, as Mr. Tiwari rightly mentions, Japanese courts, the European Court of Justice, US courts have clearly said that when you engage with a defendant or a prospective licensee, you should do so in good faith. And what does this actually translate to in practical terms? Information must be shared in the most transparent manner possible, because you have to give effect to three different aspects: fairness of what you share, reasonableness of what you share, and its non-discriminatory nature. And each is a standalone, independent issue that needs to be addressed on its own merits. Your terms have to be fair, your terms have to be reasonable, and they will have to be non-discriminatory. Therefore, merely because you've entered into a license agreement with 100 other people, that does not ipso facto prove the fairness and reasonableness of the terms that you've entered or offered a certain party. The Japanese court in Apple versus Samsung clearly goes on to say that unless and until the patentee satisfies this aspect of good faith negotiation and discloses information, assuming that he's absolutely right on validity and essentiality, he shall not have access even to a permanent injunction, forget interim injunction. So this being the law, we have to understand that none of these points are made from a rhetorical sense. This is not meant to appeal to a certain, it doesn't appeal to the heart, it has to appeal only to the mind. Now, TSDSI was mentioned, and I'll stop it only with this. The Technology Standards Development Society of India was constituted in 2013. One of the points that was made, and perhaps rightly so, is that it's open for handset manufacturers to just walk into this particular forum and contribute to the ideation, the agitation, and whatever goes on there, and they can take part in the policy that's being set. Let me explain what's happening. TSDSI is basically a standard setting body that has the blessings of the government of India, and it is setting what is known as our own IPR policy. So it's going to be our own standard setting organization. Now, when a government is part of an organization which has an industry ramification, I don't think it should leave it for handset manufacturers to walk in if they want to. It should invite representation from all relevant stakeholders because it has a ramification for every stakeholder at every level. The fact of the matter is, of all the 9 entities who are party to this particular standard setting organization as on date, there's not a single person or a single individual or a single entity from the handset manufacturer side or the chipset manufacturer side. It sets outer limits for negotiations as 6 to 12 months, which means if you don't finish negotiating within 12 months, the automatic assumption is the defendant is an unwilling licensee and therefore it's open for the patentee to press for an injunctive remedy. These are certain issues. None of these issues, which is why I said it's not a benign setup at all. It's an intensely commercial setup. And for that matter, a standard setting organization is not exactly a purely technical body. There are examples of standard setting organizations facing antitrust actions. ETSI, the European Telecommunications Standards Institute, is actually facing an antitrust action in the United States. So it's not exactly a very benign setup. I'll stop it at that. Thank you.
Yeah, thanks. I think it's
only 1 minute. I would like to put I'll take 1 minute on the point on the section 13(4) vis-a-vis section 48. I wanted to make the things clear, which in my opinion, which I disagree with Sai, that so far as the question of validity is concerned, the burden certainly lies firstly upon the defendant to come and disclose, to come and put forward a good case of invalidity of the patent. Then the burden shifts upon the patentee, not to begin with. Section 13(4) certainly creates it says that there is no presumption as regards the validity of the patent, but once the patent is granted, a patentee is entitled to enforce his patents, and the rights under section 48 are crystallized in favor of the patentee. Patentee comes, it enforces the patent. To begin with, the certificate or the LPD is sufficient to enforce the patent. Yes, when a defendant comes, he puts the ground of invalidity, a strong, good ground for invalidity, then the owner shifts upon the plaintiff, but not to begin with. This is point 1. Point 2, because this being the 4th test in the patent actions, the other 2 important tests, balance of convenience and the irreparable harm and injury. Balance of convenience, in cases of ACP, if we see the beneficiaries are numerous, it is a standard essential patent, always there will be balance of convenience in favor of implementer, where the technology implemented by the ACP implementer, the beneficiaries are 10 million or a million in India. And in that scenario, court has to strike a balance whether this implementer is a willing negotiator, willing licensee on a reasonable term, or whether he is willing to make unreasonable profit on the strength of some R&D and some research and huge investment made by ACP owner. That balance has to be created by the court at the prima facie stage to see if, in spite of this huge balance of convenience going in favor of implementer, if the implementer is not coming forward and willing for a reasonable term, then injunction should follow. But so long as the implementer is showing its willingness to negotiate, to come to a reasonable term, probably the injunction, the court may hold that injunction.
Right.
Thank you, sir.
Right, thanks. I want to ask Patrick and SK on injunction, what's your view on that? You heard Sai and Sanjeev speak.
Yeah, certainly. To me, I'll give my disclaimer. I'm a very pro-patent person. I started in the United States Patent Office. I worked in international affairs at the Patent Office to promote international patenting. I don't work with what we would call private assertion entities or trolls. I work with technology companies who develop technology and then want to exploit their patents in the marketplace. So to me, patents are very important, and they do a great deal for a global society, and I'm a big supporter of them. And it's for that reason that one of the constitutional powers associated with patent, which is the power to exclude, is important to me. And I have great problems with an American case that was decided by our Supreme Court a number of years ago, almost 10 years ago. I can't remember if anyone's mentioned it or not, but it's our famous eBay versus Merck Exchange case, which basically said that a patent does not give the owner the power to exclude, but the right to negotiate for a reasonable royalty, basically. I mean, to me, I don't like the eBay case in the United States, and I think that the power to exclude is one that's inalienable. Now, in the case of SCPs, where an SCP patent holder has made this agreement with the standard setting organization to license on FRAND terms, as I already said, those FRAND discussions can break down. And if those FRAND discussions break down, you get this reverse holdup situation, which allows implementers to continue to practice the invention and force down the value of the patent over time through litigation. And to me, that's just not the way the system should work. If I owned the patent on all the chairs in this room, and I had all the chairs taken out of here, and you all had to stand here and listen to me speak for an hour, you'd probably get pretty tired of standing pretty quickly. And if you came to me and said, you know what, I want to take a license to one of your chairs and have the chair returned into the conference room so I can sit down and relax again and maybe not have to pay such close attention to the panel talking up here. Well, you know, I'd be in a position where let's negotiate a reasonable rate, and we'd probably come to a conclusion much quicker as to what's a reasonable rate. And if you tell me that I'm exploiting my patent rights and I'm charging you more than you should otherwise have to pay, I would suggest to you that that's probably a much closer approximation of the value of the patent. And just because my patent was used to drive a standard doesn't mean that if I had kept it out of the standard, my patent wouldn't be similarly just as valuable in the marketplace if it's really an innovative, visionary technology. So to me, injunctions are an important part of the process of reaching a FRAND rate. There are so many variables that go into negotiating these licenses, and they're very, very difficult and very complex issues sometimes when you have parties who are in these divergent negotiating positions. Injunctions helps keep that framework a little tighter and helps us get to resolution quicker. And unfortunately, because of case law in the United States over the last 10 years, it's harder to do. And the recent cases that have dealt with the FRAND issues, in my mind, haven't adequately addressed it in the United States. Now, I'll let SK talk a little bit about this, but then the next point I would come back on is this decision that took place in the Huawei case with the European Court of Justice. I think that's really starting to move the ball in the right direction, and we can talk about that later.
Thanks, Patrick. Yeah, when it comes to FRAND negotiations, they are definitely legal. They have legal ramifications. They are also economical because there is a lot of royalty-based decisions involved. But what is understated and what is not quoted is the psychological factor during the negotiation, right? That's where injunctions play at the back of the mind of the negotiators. Let's look at the scenario. Once the standard is set, the standard SCP holder would want to license it to a standards implementer, and standards implementer would want to get a license to the standard essential patents. And the point of negotiation, or probably one of the most important points in the negotiation, is what should be the royalty. When two people sit across the table for negotiation, and when they are negotiating, if you have this at the back of your mind, okay, the SCP holder is asking 100 rupees. I'm just taking an example. If the SCP holder is asking 100 rupees, and as an SCP implementer, if I think that 5 rupees is the right value, right? If according to me, if that is the reasonable royalty, then there is no way that negotiation can come to the right point. I'm not saying that 5 rupees is the right compensation. I'm also not saying that 100 rupees is the right compensation. It could be 20 rupees. But when the negotiation is happening, SCP holder is already having this injunction as a tool, right? And the SCP implementer would always be under pressure to think that, okay, if I don't agree to a higher value, which is probably higher than the reasonable royalty according to FRAND, I will be injuncted out. I'll be stopped from manufacturing. My investments will go down the drain at least for some period until the injunction is vacated. So there is already a psychological factor. Under the psychological stress, it is very evident that the SCP implementer could agree to a royalty which could be much higher than the reasonable royalty, which defeats the consumerism, which defeats the very purpose of innovation related to standards, and it definitely defeats the purpose of bringing the standard compliant products to the consumer at the most efficient price levels, right? Let's say the standard implementer says, okay, I don't agree to this royalty rates. If he does not agree, the negotiation fails, and the SEP holder would go to the court seeking for injunctions, right? Injunction would bring the business of a SEP implementer to a grinding halt. So think of a world where there is no injunction available on the table. You and I can definitely fearlessly come to a logical conclusion, a legal or an economic conclusion to what should be the reasonable royalty. And if you and I cannot come to a conclusion on the reasonable royalty, go to a neutral third party who could decide what could be the reasonable royalty, right? So if in the presence of an injunction, the very purpose of arriving a FRAND-based reasonable royalty is a distant dream. So with that, what I am saying is injunctions are like gun on the negotiation table. If it is not used, then probably it's a lion waiting at the doors. If you walk out of the negotiation, it will definitely come and bite you. It will definitely come and catch you, right? So injunctions are that. Especially when it comes to standard essential patents, injunctions should not be generally available, right? Of course, there are few exceptions. If the standard implementer is an unwilling negotiating person, then definitely injunctions, and court would definitely see it, right? But for a normal negotiation, injunction should be off the table. It is either a gun on the table or a lion waiting outside the door. So injunctions are that.
Can I just add a line to what SK is saying? Just one line. In short, it's like a discussion with Don Corleone. It's an offer you can't refuse.
I just wanted to add to the points that they've made. I have not got the chance to.
Yeah, sure. And with your comments, we will conclude the round 2, which is a discussion on the issues, and we would move to round 3.
Do you want to go to round 3? I'm okay with that also.
No, I would want to
See,
hear
I think the eminent panelists have said that if there are injunctions available, the injunctions not available, then the SAP holders, SAP implementers business will go to a grind. I would say that let's not preempt the situation. What exists in the historically and what history has given us to believe, let's believe on that. Injunctions, if they are available, then only the sustenance of the business of the SAP implement holder will remain. The reason why the SAP implementer are there in the business is because of the technologies which are available to them. If there are no injunctions, it's absolutely a safe haven for the implementers to take us to the court of law. Now, let me tell you an example of how licensing takes place. It's never one patent and one technology. It's not like pharma, where you have one patent and one product. It's an ICT, where we are talking about several thousands of patents, which cover multiple products, and maybe one product can have multiple units in that. Whenever a FRAND licensing takes place, it's never a one claim chart that is there in one patent only. It's a multiplicity of the patent that are, so this is what you call as patent portfolio. So it's a patent portfolio which is given out as a license. If now consider if there are no injunction, it's a safe haven. What implementer will say, okay, let's go to the court of law. I'll harass you to the extent that you continue to prove the validity of all your patent portfolios that you want me to license. Now, do you think that it's an easy cakewalk to go to the court of law and continue to prove validity of each and every patent for which you have already gone through a rigorous examination? Absolutely not. And secondly, in the Huawei versus ZTE case, it has been absolutely made clear that hold-up does not exist. It's not the patent holder who is wanting to hold his technology, because the interest doesn't lie in holding the technology. Interest lies that technology reach to the last mile. He is not the one who is manufacturing the cell phone. He is not the one who is in a direct competition to you. You are the cell phone manufacturer. Here, we are the technology providers. It's a collaboration that has to happen. And therefore, in Huawei versus ZTE, court came out with a very strict guidelines that needs to be implemented by both sides. It's not a one-way traffic. It's a two-way traffic. It's not an obligation only on the patentee to ensure that he gives out his patent on FRAND terms and conditions. The other party also act in a good faith. And therefore, if you look at the Intex case, 13 pages goes on just to speak how much patient the standard essential patent holder has been in negotiating across the table for more than 5 years. But the other side of the table has always, violated the principle of approbate and reprobate. They've been using two different stances in two different forums. One side they said at CCI, this is an essential patent, this is valid, and the rates being asked are very, very high. We can't pay. On the other side, on the same patents, same portfolio, in the IPAB they said that patents are valid. Patents are invalid. We are not infringing, so we can't pay the royalty. So it's those kind of delaying tactics that I'm not saying every implementer is in the same bucket. There are many good people who are thinking in a good light. They are wanting to, conclude the licenses under FRAN terms and conditions, and therefore there are more than 100 licenses that exist in the market signed up. But it's only those few who want to, misuse the system and don't want to follow the rules of the traffic, and therefore injunctions definitely plays a great role in ensuring that patents are available to everyone and technology does not get hold up, and the other side of the party also behaves in a good deed.
Right, I agree. Now, Sai, we move to round 3.
That point actually...
Yeah, I don't want to comment on that, but the third round is on what's the way forward. We want to collaborate, so we have the whole idea of agreeing to a standard. Because we want to collaborate, we want to, as Patrick was saying, that it gets a chance to start off high for everyone. At the same point, we also want to compete. We want to see that our business interests are met, that each one who is there using the technology